So this is our last panel, which I was originally on, and then I got moved to the one yesterday, and now I'm moderating it, so this is all good. Our focus here is on business in the marine environment, normative adaptations, and inclusivity. I will note that there is currently some uncertainty as to whether our fourth speaker is or is not going to be able to join us. He's currently in Morocco, and due to timing of transit to a restaurant and back, it's unclear whether he's going to be online, but we'll look for him at the fourth person moment, and if he is, he will join, and if not, we will sadly miss him. But we are very delighted that our first speaker, Dr. J. Batongbacal, is here with us. He is a professor at the University of the Philippines College of Law, the director for the Institute for Maritime Affairs and Law of the Sea at the UP Law Center. We are, of course, particularly proud that he earned his doctorate here at Dalhousie University. He's a maritime law expert, has advised the Philippines in securing its extended continental shelf claim over Benham Rise and the designation of Tubata Reef as a particularly sensitive sea area, and has many, many, many other accomplishments, and we're particularly proud that you are here with us today. I will introduce each speaker just before they speak, so for now, over to you, Dr. Batongbacal.
Thank you. Thank you. Good afternoon, everyone. I'm really so happy to have been invited to speak here today on the occasion of the anniversary of the Marine Environmental Law Program and the MELAW of the law school here at Dal. I first set foot on this campus 29 years ago for a Master of Marine Affairs degree under Aldo, and it was a very important landmark in life, both academically and personally, and has shaped my professional perspective and started me on this career path. The Marine Affairs program was interdisciplinary, so I ended up spending most of my time here at the law school under that program. And the rewarding academic atmosphere and the friendly and familiar environs of Dal Law led me to return for doctoral studies under David, this time, in 2003. So 7 years later, yep, I made sure to enjoy my time here too much. I defended my dissertation on developing an ecological social justice framework for ocean energy technologies. So don't worry, this reflection of 15 years later is not about the PTSD from writing the dissertation. Yeah. Now, oops, sorry. Now, these are the dissertation contained 2 detailed case studies of energy projects in my home country, the Philippines. One of these case studies was the first ever in our country, the first ever wind farm installed there, the Northwind Bangi Bay project that you see in the photo. An early version of this case study is included in the IUCN's Governance for Sustainability handbook, which I would like to think must have given someone somewhere some idea about the social equities of wind power. I pause and reflect on this now, 15 years later, and wonder whether it might still have influence as the government of the Philippines prepares to implement over 150 wind power projects in 6 offshore energy development zones across the nation within the next 3 to 5 years. According to a study of the World Bank in 2022, these 6 zones that you see there had likely lower environmental and social impacts. But lower seems to be a very highly relative term, given that even these 6 priority zones are located in or near highly constricted and active marine areas. Moreover, they overlap the 15-kilometer band of waters adjacent to the shore, which under the Philippine Fisheries Code is referred to as the municipal waters. These are reserved for municipal or artisanal fisherfolk, and who are sometimes referred to as the poorest of the poor, operating on the fringes of the coastal municipalities. Municipal waters are already fraught with contestation, as the artisanal fishers who use boats weighing less than 3 gross tons have to compete with a politically influential commercial fishing sector, some of whom fish within municipal waters. Even without the commercial fishers' intrusion, the country's inter-island waterways are heavily utilized by both the capture fishery sector, concentrated around core fishing areas within or adjacent to the 6 identified offshore wind service contract areas. And they also compete for space with a steady stream of domestic and international maritime traffic within and through the archipelago. In my dissertation 15 years ago, I proposed the concept of ecological social justice to argue the need for rethinking how we assess the impacts of technologies on the social, not only the natural world. To truly understand and address the social impacts, especially in the context of sustainable development, we need to return to the core ideals of social justice. The interrelated principles of sustainable development, as illustrated here, articulated through international soft law, after all, revealed an underlying concern for ensuring equity, and which we should apply not only between nations, but also between citizens of these nations. Simply put, ecological social justice is social justice in the utilization of nature and its resources. It's fundamentally about how members of a human society share the benefits and disadvantages of their environment, resources, and the means and methods of access. The core pursuit is for the equitable terms of access and distribution when living in and using the natural world, with the goal that no individual, groups, or even future generations are forced to bear disproportionate burdens. I use the term ecological as a qualifier, emphasizing that all environmental problems ultimately are social problems. It's not about applying rules of justice to nature, but rather focusing on justice among the people in their relationship with nature. This perspective is decidedly anthropocentric and centered on human society's interaction with the environment. My approach differed from typical economic cost-benefit analysis and abstract philosophical theories of justice by using grounded theory to focus on actual experience and the concrete cases of injustice in order to derive practical lessons for promoting justice. This includes emphasizing equitable sharing, a perspective often linked to the developing world. Ecological social justice pays significant attention to relationships of power within and between communities and stakeholders, recognizing that these relationships influence access to resources and the distribution of benefits and disadvantages. It also aligns with the concept of guaranteeing social minimums, ensuring everyone has access to what is necessary for survival. When applying ecological social justice as an analytical framework, particularly to law and technologies like ocean energy, I proposed to focus on 3 key interlinked dimensions. Recognition, as you see, which asks the question, are the diverse cultures, values, and perspectives of affected communities acknowledged and respected, particularly their local understanding of social justice? Distribution, which is about how the benefits and disadvantages of using nature and its resources are shared and allocated among individuals and groups and generations. And lastly, participation. Are the people, particularly those directly affected, included in the decision-making processes regarding the use of their environment, as well as the technologies that are employed in them? Now, crucially, ecological social justice places technology and economy at the very center of inquiry. It uses Ursula Franklin's theory of technology as culture, or not merely tools, and every technology has the potential to be either holistic or prescriptive, emancipatory or subordinative. With respect to the economy, it relies on Karl Polanyi and his conception of the economy as a process of provisioning and economizing. Technology as culture provides the means for managing and allocating the benefits and disadvantages of the economy that is created by the utilization of nature. And law therefore plays a vital role in establishing and fixing acceptable behaviors that comprise a society's culture, and also carry out the ordering of that society and channeling the benefits and burdens of social existence. This enables us to re-examine even the case of wind energy development, which is pursued and advocated as a benign alternative to fossil fuels and nuclear energy. While the idea of environmental impact assessment has been a foundational principle in sustainable development law, note that the very term environmental seems to exhibit a bias away from the social, which in my view tends to obscure and subordinate what should be the primary objective of the exercise. The really hard cases where the needs of a human community or communities are to be weighed with the maintenance of ecological balance. Why is it that despite some of the most elaborate EIA systems, such as what we have in the country, and the industry of specialists and consultants, which we have a lot of, the Philippines still has many cases of communities being left behind in the wake of project accomplishments and profits? Is politics and greed a sufficient explanation, Or is there something more? We wish to ensure that future generations of the human community are able to maintain a stable and symbiotic relationship with the environment of which they are part. But technology, we seem to overlook, is what mediates that relationship. And how we deal with technology at a fundamental level determines how we deal with nature. Since yesterday, several of our colleagues have referred to continuing shortcomings in how, despite much progress in crafting and implementing environmental laws, we still seem to be missing the target when it comes to the marginalized, the communities on the coastal economic fringes, and the indigenous peoples. It is as if they are being sacrificed for the sake of the good of communities and stakeholders elsewhere. The best environmental laws and regulations can produce tangible aggregate results in terms of species populations perhaps, or habitat areas preserved, or income produced and productivity increased. But what are the measures for social stability and sustainability of the component local communities that might have to be exchanged for them? This seems to be the blind spot, and is exhibited by the Philippine government's latest decisions to accelerate the development of offshore wind energy. In 2023, with support from the United Nations, it commissioned the creation of a marine spatial planning tool to facilitate project design and implementation of offshore wind energy service contracts by enabling better site analysis, reducing uncertainties and potential conflict during project development. While this appears to be a step in the right direction, and most environmentalists hail how this contributes to carbon emission reduction targets, the project's terms of reference mainly to produce a detailed map of prospective project sites, which is intended to provide the basis for consultation and negotiation with stakeholders in order to ensure project success. The question that arises is, does this mean that these massive projects are actually done deals, and the public effectively is rendered into passive spectators of the state's decisions? In 2024, the Department of Energy and Department of Environment and Natural Resources signed a memorandum of agreement which resulted in the creation of interim guidelines for environmental compliance certificates under the Philippine Environmental Impact Statement System for offshore wind energy projects. This essentially created a special abbreviated process for the implementation of wind energy service contracts. What is of note is that the new process, while being big on biophysical considerations and requirements, even has a long table of various things to look out for in the biophysical world. However, it has very little to say about social acceptability and social impacts, other than to mention that community stakeholders will be consulted to identify project research requirements and potential impacts and assess and address any risks. There is no mention of any guarantee of opportunity for public participation and benefit sharing, which are key to anticipating and addressing issues of social justice. The danger, therefore, exists that insofar as offshore energy is concerned, the role of the public in the process of project implementation may become nothing more than routinary or a formality. This is a significant issue because ultimately the energy generated by wind farms is not intended to be used by the smaller host community, but instead used to feed into the national grid, and therefore beneficiaries elsewhere far and wide in the country. So when I wrote my case study of the North Wind Bangi Bay project, I highlighted how social justice was promoted by direct personal relationships and communications established by the company with the community, and how the trade-off between environment and development was made tangible by royalties from energy generation. Today, official statistics show the town of Bangi as experiencing declining poverty rates while remaining largely conventional and unurbanized, which seems to be an indicator of sustainability. The new processes, however, raise questions about the trajectory of the project approval implementation process for offshore energy renewables. They exhibit the tension that arises from environmentalist policies that fail to appreciate the social ordering that is induced by technology through its effects on culture, which ultimately tend to detract from the promotion of social justice, particularly through the enhancement of public participation and distributive justice. What I wish to guard against is for the renewable energy sector, here represented by offshore wind energy, and intended for the beneficial purposes, to end up sacrificing the interests of local communities at the margins. Sustainable development is indeed a lofty goal, and we hope to achieve the elusive balance between economy and environment, but we should not do so at the cost of those most disadvantaged. So thank you very much for listening.
That was an extremely interesting presentation for many reasons, including, of course, as we'll hear a little bit more about shortly, the real push to develop offshore wind in Nova Scotia now, and I think there are probably a lot of lessons to be learned from what you just shared with us. And so, we are now joined by Dr. Mohamad Alikhani, who is a research fellow at the Marine Environmental Law Institute and a recent PhD graduate of our program, with supervisors that included, well, supervisors and committee members that included David Vanderswag, Patricia Galvao-Ferrara, and writing on offshore wind. So his research interests include energy law, climate change law, ecological law, sustainability, and marine spatial planning. Welcome.
Hello, everyone. I'm so delighted to be here today to talk about building an effective regulatory framework for offshore wind energy, one that is grounded in ecological sustainability and guided by marine spatial planning. This presentation explores how ecological normativity can be meaningfully integrated into legal and policy frameworks, shaping Canada's offshore wind energy future. So it's 2025, and Canada has 3 major ambitious targets to achieve by 2030. The first one is the climate goal, which is a 40 to 45% reduction in greenhouse gas emission from 2005 level. And the second is the biodiversity goal, which is protecting of 30% of land and water, which is under the nature strategy goal and guided by global biodiversity framework, which is under the Montreal framework. And the third goal is the development goal, which is the commitment of Nova Scotia to offer 5 gigawatts of offshore wind energy by 2030. So the question is how we can reconcile these 3 objectives in order to have a sustainable energy transition. So from my perspective, an effective regulatory framework must be grounded in ecological sustainability, which means protecting ecological integrity. And this concept has been defined under the Oceans Act. Under this act, ecological integrity means a condition in which the structure, composition, and function of ecosystems are undisturbed by human activities. Natural ecological processes are intact and self-sustaining. Ecosystems evolve naturally, and an ecosystem capacity for self-renewal and its biodiversity are maintained. So offshore wind energy is a climate solution, but we need to see how we can develop offshore wind energy while not at the expense of ecological integrity. So I think the development of offshore wind energy individually or in a combination with other projects must not be harmful to ecological integrity. Based on the comparative study that I did in my PhD program, specifically my thesis, in other jurisdictions, many countries have advanced marine spatial planning, which is an operational tool in order to include different marine activities and reduce conflict between them and their conflict with the marine environment. So, offshore wind energy has been a catalyst for development and advancement of marine spatial planning. those jurisdictions, like the one that I explored in my PhD program, UK, Germany, and Denmark, they have established a robust and mandatory process for marine spatial planning in their jurisdiction. So it is a suggestion that Canada should have the same mandatory process for marine spatial planning, and that marine spatial planning must be grounded in the binding process under a specific act, and it should be inclusive in terms of engaging coastal communities and public in general, and must be based on ecosystem approach, and it should include various programs, plans, and policies that are currently existing in Canadian legal framework. It must also be aligned with the federal provincial cooperation system, like the one that we have in Canada, Nova Scotia Energy Regulatory Framework. And those plans, there should be other plans specifically for offshore wind energy or other marine activities in order to be aligned with the overall plans under the ocean strategy, which is designed under the Oceans Act. There should be also a coherence legal framework between the marine spatial planning, the overall plans and specific plans, with other regulatory laws and regulations. For example, in the case of offshore wind energy, Canada, Nova Scotia regulatory framework. And above all, the marine spatial planning must be grounded in protection of ecological integrity. So when I see the current plans and policies in Canada, I see a major gap in the current regulatory framework for offshore wind energy, specifically, based on the comparative study that I conducted in my PhD program. There should be a binding process for marine spatial planning, and that binding process means setting a specific target in order to get marine spatial planning done, and it must also be inclusive and engage coastal communities, stakeholders, and the public in general. So the final question is how we can integrate ecological integrity into the policies and legal framework for offshore wind energy. First of all, I think protecting biodiversity and ecological integrity must not be an afterthought. It should be, biodiversity protection should be mainstream in every decision-making processes. Marine spatial planning must be advanced, and the operational tools for advancement of marine spatial planning are strategic environmental impact assessment and environmental impact assessment. And the development of offshore wind must not be in sensitive areas or marine protected areas. Those areas should be avoided in the development of offshore wind energy. And other impacts, every human activity has its own impact on the environment, and offshore wind energy has its own impact. But those impacts must be avoided as far as possible, and they should be minimized. And when it is not possible to be avoided or minimized, there should be a compensation regime in order to compensate the marine environment. So, in conclusion, in order to reconcile those three objectives, climate change objective and biodiversity and economic goals, we need to look all these objectives at the same time and integrate them into the legal and policy framework. Secondly, the ecological integrity is the main goal from my own perspective. It must be the foundation of legal and policy framework. And more specifically, there should be an amendment to the Oceans Act in order to include marine spatial planning. Thank you very much for listening.
Thank you very much. I'm going to get up our next presenter's slides in just one moment, but I'm just going to offer a reflection to kind of connect the past session to this one and to where we're going to go next, which is Akin is going to bring us into the business and human rights world, which is a world that I've spent a lot of time in, but I think most people in the room probably have not. And the reflection is this. There's a forum that's held in Geneva every year, or has been since 2011 or so, which is called the Business and Human Rights Forum. And it's a multi-stakeholder forum which has governments and NGOs and many indigenous groups and also many large multinationals. And a number of years ago, I went to a session there that was on green energy. And the part that was most striking to me was a multinational that was speaking about green energy and its great public participation processes. And this was a European company that said, we used to be a fossil fuel company, but now we are 70% green energy transitioning out. And so there's a really interesting conversation and sort of linkage between, on the one hand, where we ended the last one, like let's sue the fossil fuel companies, and on the other hand, maybe some of those same companies are the ones that are moving forward with some of the offshore wind things that are being talked about. And to me, that's kind of interesting and not something we actually recognize that often. So let me find the PowerPoint, introduce the speaker, and we'll go from there. And now I am delighted to introduce Dr. Akinwumi Ogunranti, an assistant professor of law at the University of Manitoba, who also earned his LLM and PhD degrees here at the Schulich School of Law. He writes and publishes in business and human rights field, focusing on corporate accountability relating to human rights, climate, and environment issues. And I'm particularly proud because he's one of my PhD grads. So welcome, Akin.
Thanks, Sarah, for the kind introduction. Two preliminary thoughts. I always find an interesting way to come back to Schulich School of Law. So it's a joy, it's a pleasure to be back. And I know I'll probably be back anytime soon because I always have that connection back to the law school. And I'm very grateful for the invitation for this conference. The second thing is, it's good that Sarah is the moderator for this panel. That means she doesn't get to ask a question. She doesn't get to ask a question, but I am, let's get right into it. Right. So the topic for my discussion today is Business and Human Rights Treaty after a decade, a tale of legitimacy crisis. That was my question when I started researching on this topic. This is a paper that is under peer review, so I'm hoping that I can get feedback to strengthen the paper. In 2014, the UN endorsed or created an intergovernmental working group to look at the possibility of creating a treaty to regulate transnational corporations, right? And let's just say, let's call it a working group, right, for the purpose of our discussion. So the working group has met 10 times since 2015, right? But in order to facilitate the treaty discussions, the working group chose a multi-stakeholder initiative, a framework that invites states and non-state actors, right, to discuss the possibility of having this treaty. Prior to 2005, right, treaty discussions, especially relating to human rights, are always centered around states. But starting from the Global Compact, you see that non-state actors, including NGOs, corporations, have entered into the mix, right? So it's been a decade since the working group started its deliberations, right? What we know previously about multi-stakeholder forums, multi-stakeholder initiatives, usually for CSR, corporate social responsibilities, are now being transposed into global governance mechanisms, right? So the question is this. Considering the session so far, is the working headed headed towards producing a legitimate business and human rights treaty, right? And I'll define what I mean by legitimacy soon. But what I did in my research is to look at the sessions, the 10 sessions. What are the stakeholders saying? How can we decipher whether we are heading towards something that stakeholders can legitimately call their own, the ownership of that treaty? So I relied on Mina and Palazzo's theory of democratic legitimacy. They propound that in order to determine whether a multi-stakeholder initiative is democratically legitimate, you must look at the framework. Can stakeholders work together to actually produce an instrument, produce a document, such that that document is a product of a collaborative effort to solve a problem? And so they use an analytical framework, looking at the input legitimacy and then the output legitimacy. The input legitimacy, so to speak, talks about the procedural framework for gathering stakeholders rather, in discussions, in multi-stakeholder discussions. How is the procedure formed, right? How are we talking about inclusion, fairness, consensual orientation, and transparency? But let me break the input legitimacy down in just 2 minutes. Stakeholder inclusion talks about who are the affected parties, right? Are the affected parties in the room? If they are in the room, then there is a possibility of having a legitimate document or legitimate instrument. Number 2 is procedural fairness. Number 2 is talking about even if affected parties are in the room, are their voices dominated by stronger parties? The third one is consensual orientation. And it talks about the ability of stakeholders to work together. Sometimes some stakeholders may have a legitimate concern or even argument. The ability of those stakeholders to actually prevail over others. That's what we mean by consensual orientation, the ability to work together. Transparency, it's straightforward. The processes of the framework. Are parties able to, request for information and they get it promptly? So if we move away from the procedural framework, then let's talk about the output legitimacy. Is the document able to solve the problem, or is the instrument able to solve the problem that the stakeholders have come together to discuss about? And under output legitimacy, we have 3 subheadings there. You have eye coverage. Is the document able to cover the issues, especially the subject as in this case, transnational corporations. And so if there is a possibility for high coverage of the issues and the subject matter, then it's possible that we may have output legitimacy. Rule efficacy talks about the document's force or the document's ability to solve the problem the stakeholders have come to discuss. Number 3 is, does the document or instrument guarantee good enforcement and monitoring of its rules? Are we able to enforce those rules? Now, this is a theoretical framework for determining whether a multi-stakeholder initiative is legitimate or democratically legitimate, right? And this is what Mena and Palazzo have laid out. My job is to assess the United Nations Working Group's MSI framework using Mena and Palazzo's framework. Right. These are my arguments and my conclusions. Number 1, input legitimacy. Stakeholder inclusion. When we talk about transnational corporate accountability, who are those affected? Of course, local communities, environmental defenders, right? We talk about a range of actors, not just states, not just NGOs. So the question I raised is, when you look at the UN framework, non-state actors are accredited, which means that local communities do not have a voice, except if they are represented by NGOs. That raises another question. How do we determine problems of representation, right? So it becomes a problem that, do NGOs actually represent the voices of local communities? And that was the first question I raised. But assuming they even do, assuming they represent local communities, there's a logistic problem going on with the UN, especially representation from Global South NGOs. They do not have the funds. They cannot travel to the UN. And some of them have raised that concern, as at last year, which was the 10th session, right? Some of the NGOs raised an issue that the forum or the session was postponed, right? And they had to cancel their flights. So the question is, how do the NGOs then get themselves to Geneva? Considering the fact that although the sessions were originally online, now it's in person. So it becomes an issue of who is included, who is in the room. The second one is procedural fairness, and I'm going to be quick about this. Even if NGOs and local communities are in the room, when I looked at the 10 sessions, I realized that the agenda setting, right, it's lopsided. We have some group of states saying, this is what we want. And then the other groups are like, look, we either voice our dissent and it's not taken, and then we go with whatever you say. But I'm not going to go into examples now because of my time, and I have 2 minutes remaining. Interesting. But the third one is promotion of consensual orientation, right? Are parties able to work together to regulate transnational cooperation? My research shows no, right? The states are divided along economic and political lines. Developed countries on the one hand, developing countries on the other. And so parties are only pursuing their economic and political interest. And in that way, it's impossible to have a consensual orientation. Transparency, yes, because we've had 10 sessions and members can join online, can view the sessions online. People can view the sessions online. The working group also publishes its report, the statement, and some of it of deliberations, the input from states. All of those are online. So in that respect, I still give a transparency a check mark. Now, output legitimacy. Is the treaty, the final treaty, is it able to give us what we want? Regulatory transnational corporations. I argue that when we look at the coverage of the treaty, and I look at it in terms of the subject matter of the treaty, right? previous versions or previous drafts of the treaty recognize the intertwined nature of human rights, environment, and climate. So when you look at the preambles, it actually expressly incorporates these responsibilities for corporations. But the fourth draft, which came in 2023, did not recognize this. So without holistically providing or giving that framework for corporations to observe, it's impossible to have a siloed instrument. So in that way, it is impossible to have a legitimate treaty. When you then talk about rule efficacy, look, the treaty only imposes obligation on states, not multinational corporations. Previous drafts, especially the one proposed by South Africa, imposed obligations on multinational corporations. But the latest draft does not. So the question is, would that be effective? Don't states already have obligations to protect individuals within their territories? Right? So the third one, and I'm promising to wrap up now. The third one is enforcement of the rules. The enforcement, the treaty or the draft treaty provides that states should report their activities, blah, 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 and ensure that they comply. But the question is, if developed countries don't comply, what happens? The WTO is a perfect example, right? To the extent that if developed countries don't comply, who is going to enforce it, right? So it becomes a problem. And just to put it simply, the working group proposed that the treaty enforcement or the treaty program will be funded by states. The question is, if, say, for example, they do not comply with the treaty, and of course, maybe the ICJ or one of the tribunals rule against them, they are likely to withdraw funding from sponsoring the treaty. So in that regard, when you look at the three items or the three elements there, you see that it doesn't pass it, right? And I conclude in my paper that three things can happen. Number one, the treaty can be abandoned. And I gave an example of a previous initiative that was abandoned 22 years after. We are only 10 years into the treaty now. Even if the treaty is passed and everybody's happy, they have to dance to the tunes of the developed countries. And so it will be weak. The third one is, even if developed countries agree that the treaty should go on, and then with strong mechanisms, it's not going to be signed or ratified, right? So I don't want to be a prophet of doom, but what are the alternative paths? And I look at the contemporary development now. We see that there is a rise in regional instrument that seeks to regulate at least some aspects of corporate behavior. And I said, look, if you will look at the EU has its own regional directive. Africa is gradually coming up, though not there yet. Latin America and the Caribbean are also coming up. So maybe these norms, the regional based norms, can coalesce at some point to influence international law norms. But as it stands, there is a potential for the BHR Treaty to not to be legitimate in terms of the theoretical framework that I just put on. Thank you.
And that wraps up this panel, but there is an awful lot of very interesting conversation that could be had here. And I will not ask questions of Akin, although I will be talking to him afterwards. But I will say that it would have been really interesting, I think, and I know you couldn't be here yesterday if you'd heard Elizabeth Marima talking also about treaties, because there is this kind of, if only we could get a treaty, and then sometimes you get a treaty and there's a long list of those that never actually got into force, and even if they are enforced, then there's big questions of compliance and enforcement and so on. But for now, I will open things up for questions, starting with David.
It was a very interesting panel, and thanks for the presentations. I was really struck by the two presentations of former DACA students Jay having social-ecological, and of course, Mohamad ecological. And I guess I'm going to come back to the social issue. A huge issue that's emerging, and you see it in the Philippines, you see it in Nova Scotia, are the social dimensions, not just the ecological. And it's this issue you saw in the Philippines that Jay mentioned, where the energy may be produced, then it gets shipped off to Manila or some other city that needs the power. And then you look at Nova Scotia, not only you have that issue, but then you have the global issues that come up with the green energy, and you want to ship your hydrogen off to Germany. And we're already seeing some local disappointment, saying, wait a minute, where's the energy going? And why are we taking all the pressures here on our environment or social dimensions? So the social dimension is very important, and I think that one is a really hard nut to crack. And I want to come back to you if you have some thoughts on that. You read spatial planning. You mentioned amending the Oceans Act for ecological integrity. But what about the social dimension? And is that something to be done through spatial planning, or do you need other legislative moves to get there? I'm thinking of clean energy legislation, for example. I'm trying to give you the answer as I go along. Jay, I'd like to hear what you think is the future of that in the Philippines. You mentioned spatial planning really like a project right now. Do you need legislation? And how do you get the social dimension in there? So it's a question to both.
Yeah, on the perspective that I took up in my PhD program, there are a lot of reasons for the perspective based on ecological integrity and more generally ecological sustainability. Based on ecological sustainability, ecological norms and values are primary consideration. It doesn't mean that we shouldn't take other consideration into account, including social justice. So there is a reconciliation between these two objectives, but there has been a lot of debate on which one should be taken into account as the primary objective, and which one is the secondary objective when there is a conflict between ecological objectives and social objectives. So the current anthropocentric approach towards development doesn't provide, from my own perspective, doesn't provide any specific answer. They are going to strike a balance between ecological objectives and social objectives, but to me, that's not a correct answer. The correct answer, we should take ecological integrity and ecological perspective as the primary objective. If there is any sharp conflict between these two objectives, the precautionary approach will say no to development. But if there is a foundation for the current legal, assuming that there is a foundation under the current legal system based on ecological sustainability, we will make sure that our non-negotiable baseline, which is ecological integrity, remains intact. So we will come to the negotiation table at social process whether we can compromise other part of the environment or not. So the baseline is ecological sustainability, which is non-negotiable. So in case of conflict, we say no to development based on precautionary approach, but it doesn't mean no to any kind of development. So other parts of consideration like social justice issues will be secondary issues which should be dealt under ecological sustainability perspective.
Thank you. Yeah. Okay. What I think is that is marine spatial planning the future, and how do you get the social dimension in there? Okay. First of all, with respect to the marine spatial planning, it is a tool, and it's expressly described as such, but it also has its limitations, I think. Based on the project's terms of reference for the Department of Energy, and I'm reading it verbatim, the aim is to establish an offshore, what is this? An MSP tool for the Philippines to facilitate development of 31.5 gigawatts of projects, offshore wind projects, and to reduce uncertainties and potential conflict during subsequent project development stages. So clearly, it's more of a tool for developing a map. So it will help probably in location of facilities and minimization of conflicting location. These locations creating conflicts with other users. So that's one step. But again, as you also note, the social dimension is not there. There's only so much you can do by avoiding each other. You know? Especially when it comes to the offshore, where you have activities like fishing. It's not simply a matter of location, but also a matter of access to the locations. So even if there is no conflict in location, if that is an obstacle to access to your resource area, it can still create problems. So, the only way to find that out, I think, looking back at my dissertation, it's really through, again, looking at those three dimensions I mentioned. In terms of participation, there's a need for direct, simple communication between the proponent and the stakeholders, the communities themselves. And that communication must be open and flexible. It's not like what usually happens, which is that it becomes part of procedure where you have a specific day or date to conduct consultations, and then that's it. There's no more continuation afterwards. In that instance of Bangui, there was also a personal presence in the form of the company's chief officers being actually present in the project site, and therefore being able to establish direct personal contacts and communications with the community and community leaders. And the fact that by doing so, by establishing those direct personal relationships, the other communication channels, aside from the official company communications, you also had that personal communication between the community members and the company officers. So I think that is what helped integrate the company into the community. It became part of the community, essentially. With respect to the factor of recognition, it was on the part of the company early on recognizing that they needed to be, they recognized that these are stakeholders, they will be affected somehow even if they weren't aware yet what that impact would be. Even the smallest impacts were considered, they talked about it and they tried to address it. They also recognize that there's that interdependence between the company's operations and the fortunes of the community. They're very conscious of the fact that they would, the payment of taxes contributed to the coffers of the municipality, as well as the barangay or the village, because they got royalties from that in addition to taxes. And so that helped create that sense that they were in this together, in a sense. So they were really stakeholders, common stakeholders. And lastly, with respect to distribution, it's both the benefits that were derived from taxes and royalties, but also what I look back now as and describe as extra mile benefits, where even though they were not required by laws like taxes or royalties, the company took it upon themselves to provide the community with additional benefits, such as voluntarily establishing a tourism center because the project at the time became a major tourist attraction, and providing a venue for local people to set up like small shops, basically build the small tourism-oriented businesses around the project site. So I think that's something that they really didn't have to do, but as I found out, they decided to do it anyway because it was an outcome of their constant interaction with the community. And so that's why I think that in that instance, as far as the community was concerned, the entry of the project into their area was really a benefit that they accepted. So even if the energy generated is exported outside of the community, they accepted it. They did not have a problem with it because they knew that they were getting something in exchange for that.
Thank you, that's super interesting. Aldo?
Is there time?
Yeah, yeah, we have lots of time.
Okay. Thanks very much. Very interesting panel. I have a couple of questions for Mohamad. Very interesting one. I'm wondering, when if I understood correctly, you said that marine spatial planning should be legislative. Whether you meant an amendment to the Oceans Act itself or regulations under the Oceans Act, because Articles 31 and 32 are very permissive and could easily accommodate the adoption of marine spatial plans. So essentially, there is already kind of a framework. So I suppose the question is, if there is that text already, why you need to amend it itself, rather than regulations on marine spatial planning, similar to the Marine. And then following on that, probably I'm assuming from your research that you explored the past experience with attempted development of large offshore management areas. And it didn't work in the Atlantic with Eastern Integrated Management Plan. It did work perhaps in the Beaufort Sea, or at least there was more control there. And I'm wondering if you feel that there is a change in the conditions, that there's a greater likelihood that marine spatial planning will work rather than offshore management areas.
Yeah. On the first one, I think there are bases under the Oceans Act in order to promote marine spatial planning. But the problem is at the implementation stage, because of the previous 30 years of experiencing different kind of policies and plans in Canada, I see a major gap under the Act. There is marine integrated management under the Act, under the leadership of DFO. But the problem from a legal perspective is there is no end to, although marine spatial planning is a process, but there should be one comprehensive plan for all marine areas, as I investigated in other jurisdictions. So with that mandatory process or amendment, what can be solved is setting targets, specific targets. For example, let's say 2030 will be our target in order to establish the first marine spatial planning, but that will not be the end of that process. That there will be adaptation in terms of ecological system and in terms of social processes and new developments. And that plan should be revised, for example, in every 5 years period. Under the regulations, I'm not sure which speculation can be fixed when it comes to marine spatial planning. But overall, I think there should be another step from integrated marine integrated management under the Ocean Act, which is a concept, to an operational tool, which is marine spatial planning. So, on the second one, there have been some progresses over the last 30 years, including ESIM that you mentioned. I do not want to undermine those kind of progresses over the last 30 years, but those plans and policies should be integrated in one plan. But the problem with those plans, they stay at descriptive, general, high-level stage. We need to see what activities are currently in marine areas. I cannot understand when I review those kind of policies and plans. Second one, we need to see the future. Sustainability means how we can perceive the future of marine areas in terms of economy and in terms of environment. I cannot understand from the current policies and plans what will be the future of offshore areas. So marine spatial planning will facilitate to get our existing and future plans done in one comprehensive plan under marine spatial planning process.
Thank you. Ian?
I have a question for, it's really, why if the experience that you had when you were doing your PhD 15 years ago, that is say, sorry, whatever the date was, your experience with the offshore wind company back then, what do you, I didn't quite catch from your paper, why do you think it's become the societal engagement side of things in the Philippines in the offshore space has become more of a, I'll call it a box checking exercise? Why has it become bureaucratized? What was a kind of a greenfield experience 15 years ago has now become routinized?
Yeah, well, you could say that in a way, because people have gotten so used to these things, perhaps it has become so routinary. Like somebody creates a checklist and then they just check up on it. The first case, that first wind power project was the first of its kind, and therefore there was much room for innovation and improvisation. Actually, the EIA process that they went through. Even though there was already an existing system at the time, they were actually exempt from it. And yet they still improvised. They used the system even though it was not required, in order for them to be able to comply with the requirements of the Danish funders. But that also enabled them to engage the community in a way that they would not have done if they simply followed the minimum requirement. Now, the problem is that with yes, it was Danish. It was a Danish company. The problem now is that with so many of the companies now about to enter into the field, the experience of the first will probably not be replicated. The people will be in a hurry. The government is in a way under pressure to make sure that these projects are implemented as quickly as possible, because our energy supply situation is actually not so good. There's not much margin for error in supplying the energy. So there's that pressure to speed things up. And these recent moves, you know, to abbreviate the process and to use this MSP tool, you know, while they seem to be good at first, you know, at first sight, that's what I did, however, notice that, yeah, they basically are bureaucratizing it. And the issue of social acceptability, in a way, has been subsumed. No? Perhaps they're just assuming that it will be taken care of. No? But the regulations do not provide for it anymore. No? That's the source of concern, because the tendency with these projects is that if they're taken over by engineers, essentially, I mean, they'll just go ahead and do the job. Relating with the community, finding out the impacts on their daily lives, etc. Those are not things that engineers are trained for. It's something that community organizers or social scientists would be suited for, but they're not. They're not usually. They don't usually play a role in project implementation unless it's required by the EIA process. But if the EIA process is abbreviated, and one of the things that appear to have been cut out of it is the social acceptability part, then it becomes a concern. So,
May I follow up with a question if there are any?
There is one other question. Did you want to?
Mine
Yeah.
was for Mohamad.
Okay.
And it seems like when you're talking, well, I guess I'm having a problem with the term normativity you brought up, because I'm thinking of Saginaw St. Lawrence Marine National Park. The whole engine for this area being turned into a national park is there is a cold water current that comes from the high Arctic around Newfoundland, follows the floor of the St. Lawrence, and in a very, very short space, it goes from being 330 meters deep to 20 meters deep. And so there's a very, very strong upwelling there. There's a mixing of fresh waters from Great Lakes and coming down Saguenay. There's a mixing of this water that by the surface was the same salinity and same temperature as the Arctic Ocean outside of the Arctic. It seems that something that powerful would continue to be a very powerful process in the area, and yet in the last 10 years there have been very significant changes in the area, and that amount of upwelling is drastically decreased because of warming waters, surface waters in the St. Lawrence. And so I guess we have a marine protected area there. In the past year, it's more than doubled the size of what was already a huge marine protected area. But how do you, now we've got other areas of upwelling being, starting to become more important, and the way that the fish school, the way that the marine mammals are, the way that the winds work, everything's, changing. So how do you use things like that in your model to avoid sensitive areas and use marine, spatial, and marine park planning?
Yeah, thank you very much. That's a very interesting question. Actually, the reason why, one of the reasons why I have been proposing ecological sustainability and ecological integrity as the foundation of legal and policy framework is the changing environment. We cannot predict our changing environment, ecosystems, so we need to be adaptive in terms of legal and policy frameworks. And your question is how how is a kind of operational question that I try to answer with legal policy operational tools such as strategic environmental assessment, environmental impact assessment, and more generally marine spatial planning. Because at the end of the day, we are, as human beings, should decide about the development around us, including offshore wind energy. The environment cannot speak about its processing and changing processing. So, strategic environmental assessment and EIA and MSP all are grounded in gathering scientific data and information. So every decision making, apart from social consideration, should be grounded in what would be the impacts of our activities in marine area, including the changing environment. We cannot stop global warming by easily saying we want to stop it. We should assess the kind of activities we have in terms of policies. When it stands for policies, we should formulate policies based on strategic environmental assessment, what activities should be allowed, what activities should not be allowed, and when we want to allow an activity, a specific activity like offshore wind energy, we need to see its impacts on the marine environment. Apart from that, there will be definitely exclusion areas like marine protected areas that we mentioned. So in the policies and plans, it will be clear that what are the current marine protected areas and what would be the potential areas in the future, because there are targets in order to conserve the marine environment. What would be the potential marine protected areas in future? And we integrate all these objectives in one policy and plan, which will be comprehensive under marine spatial planning, and adopt and adapt as time is going, and based on the future developments. So that's what I can say about the changing environment.
Thanks very much. In light of the time, we should probably wrap up and leave further questions down for conversation afterwards. I know there is a business and human rights conversation to have with Jay about human rights due diligence and expectations of businesses and financiers, which I'm guessing was in part what was going on with that Danish original project. But I'm not going to ask that, and we'll talk about that in a few minutes. So with that, I want to say thank you very much to this panel. And then after we clap, I'm going to just do a quick wrap up, and then we can finish up. So rather than having any, you guys can stay here if you want, because I think, did you get a photo? Yeah. Okay, she wants a photo. But I'm just going to keep talking while you take the photo. Is that okay? All right, great. Okay, so just in the interest of not prolonging, taking a break and then coming back, I'm just going to say a few concluding words. First, just thanks again to everybody for being here, contributing, to the people who were here yesterday. For me, this has been really fantastic. We don't often get opportunities to hear what all of our colleagues are up to, and I'm really, really pleased with everybody's engagement and participation, and I think that was fantastic, including our more junior scholars as well as our more senior, and that was really a treat. I want to reiterate my great thanks to Lori, who's done a tremendous amount of work to pull this together. Also to Dave Dada, who's done a tremendous amount of work to pull this together. And to Spencer, doing the filming, to Julia, who's here doing our Zoom moderating, Rihanna, who's had to leave, and also to our sponsors, who I'd noted earlier, but I want to actually reiterate how grateful we are to Dalhousie itself for having put a fairly strong amount of funding towards this through the Next Wave Funds initiative. So I'm very appreciative about that. You will be hearing from us in terms of some next steps. You may recall that one of our plans was to put together what we're calling a proceedings. So we will be working on getting sort of short summaries of people's presentations that we can pull together. And so you will hear more from us about that in due course. And so that's it. I'm looking forward to whoever can join us for dinner. Let me know if you want to meet up front at 4:30, or if we want me to find you at your hotel at 4:40. Yeah, what a great celebration. Thanks, everybody.